The Corporate Transparency Act originally applied to 32 million American businesses. Failing to comply meant facing a compounding daily financial penalty of $591. Advice or articles published in 2024 are now dangerously obsolete. A series of federal rulings and regulatory pivots have changed the target list for this law. We can trace those 32 million companies through a new set of regulatory filters to see who remains under government scrutiny. Every business owner must locate their entity on this updated map. Your specific corporate structure determines whether you are safe or legally obligated to act. Understanding these specific filters transforms a complex bureaucratic threat into a manageable checklist. In March 2025, the Treasury Department issued an interim final rule that significantly reduced the number of companies required to report. The first filter removes any entity created by filing a document with a U.S., state, or Indian tribe, covering almost every domestic LLC and corporation. These domestic businesses no longer have any initial or ongoing BOI reporting obligations. The requirement is legally lifted. Most American small business owners can now ignore the CTA. Enforcement risk is now focused strictly on foreign operations. This leaves foreign entities that have registered to do business within the United States at the bottom of our filter. For these registered foreign companies, the government requires the identification of every beneficial owner. An individual is a beneficial owner if they own at least 25% of the foreign entity or exercise substantial control over the company, like a senior officer. Crucially, the 2025 rule excludes U.S. citizens from reporting. Their data remains private. Foreign reporting companies must submit 5 data points for their non-U.S. beneficial owners: full legal name, date of birth, their residential address, an ID number, and a digital image of it. FinCEN uses the CTA as a targeted tool to identify non-U.S. individuals who control foreign entities operating on American soil. For the remaining foreign entities, the initial filing is the start of an ongoing compliance cycle. Newly registered foreign companies must file their initial report within 30 calendar days of their U.S. registration becoming effective. Any change to reported information, such as a new residential address or a renewed passport, triggers a strict 30-day window to update FinCEN. Missing this 30-day window results in civil penalties of $591 per day. Banks now integrate BOI verification into their regular customer due diligence. An entity that fails to maintain accurate, updated records faces frozen accounts and a loss of access to the U.S. financial system. Establishing systems to track ownership data allows businesses to meet these deadlines and maintain uninterrupted operations. In 2026, foreign entities operating in the U.S. face a strict, ongoing clock management mandate to keep their reporting current and their access to the market secure.